This is in the District Court of Elk County, Kansas, case entitled in the matter of the marriage of Antonio Manuel Perez Beal and Sidney Page Simon. It's case number 2023 DM 300003. I will note that Mr. Perez Beal appears along with his attorney of record, Ronald Wood. Sidney Simon appears separately from her attorney of record, Lauren Schuler. This matter comes before the court at this time for further proceedings. Counsel, this court had conducted a trial in this case, made rulings and orders which should be journalized by now. As far as I know, the court does not have a journal entry of judgment and decree of divorce submitted as of this point. I also note that Mr. Wood has moved to withdraw his counsel for the petitioner in this case, which has actually been objected to by the opposing party. So I'm going to start with Ms. Schuler and ask her, where are we at on this case?
Thank you, Your Honor. Did you receive my
exhibits? I'm not hearing her if she's talking.
You can't hear me, Your Honor?
Audio speaker.
Can you hear me now?
How that could have possibly got turned down, but Ms. Schuler, if you try to speak once again.
Testing, Your Honor. Okay.
You're good now. Please proceed.
Thank you, Your Honor. So did you receive my exhibits?
I did.
Okay. So I did draft a journal entry. The proposed journal entry is Exhibit A. I did supply the email that I sent the journal entry, showing that I sent the journal entry to counsel, Mr. Wood. I sent that on Tuesday, May 13th. As you stated, we did have trial on May 7th. I did supply as well, which is reflected in the court filing, Exhibit C, which is Mr. Wood's objections. If you look at the objections, Your Honor, unfortunately, a majority of them are not actual legal objections. They are essentially requests to change your ruling. And I can go into further detail, but I would argue 80% of them are just requests to change your ruling. They're not actual legal objections. And I think that's where we're at a standstill. I was waiting on this hearing.
What about the other 20%?
I did make
corrections that are appropriate.
I did make them.
Okay.
So specifically objection 1, 3, 7, 17, and partially 14 were all made. Missing a comma or referencing specifically the parties for joint legal custody. I did make those. But outside of that, the others are requests to modify your ruling. So I was waiting on this hearing to file a motion to settle the journal entry. So that's where we're at on the journal entry. I will wait to go over my objection to the motion if you would prefer that.
All right, Mr. Wood, as far as the court's concerned, the court wants to settle this journal entry before allowing you to withdraw. I do understand the nature of your motion in this case, but I do note that on behalf of your client, you filed certain objections back on June 3 to the wording of the proposed journal entry of judgment and decree of divorce. Some of these cosmetic changes have been made, apparently. I understand that your client may not be 100% in agreement with the court's ultimate rulings in the case, but what this journal entry is intended to do is to simply document what the court did rule upon. So what's the problem here, Mr. Wood?
Well, Your Honor, I received from my client approximately 4 pages of changes that he wanted to make in the journal entry. I took those the best I could and made those objections known to the court the best I could that would not be considered frivolous or completely not allowed in this type of a review of the journal entry. So I did what I could. And then once I did that, then I received wording from my client that he was did not approve of what I have objected to, and wanted to know why I didn't use everything that he'd given to me as objections in the journal entry. So I did what I could to pare it down. What really concerned me, though, also is that I filed that on June 3rd, but on his what he had sent back to me objecting to what I'd sent, he'd start sending copies of that to the disciplinary administrator. And so that concerned me whenever the disciplinary administrator gets involved and indicates that, you know, she didn't want to be involved with that. So I understand the court's position on withdrawing, but I had to put forth the objections that my client in some manner objected to, with the understanding that I think some of his objections really would be more of a motions for rehearing or motion for modification. And that's a little bit of a problem when people are using the internet or whatever they're using to come up with attempting to practice law. And so they don't understand the distinctions between those and the objections to the journal entry. You know, the journal entry is supposed to recite what this court had ordered. And it's not to be the objections to what the court had, or whether you agreed or disagreed with what the court ordered. The journal entry is to reflect what the judge ordered. And whenever I get something saying, no, these are all the objections I have to the journal entry, and I'm sending these copies of all this to a disciplinary administrator, that concerns me, that I've got someone, watching over my shoulder. He doesn't trust my abilities to do the work that I'm doing, doesn't understand with 46 years of experience that I know what I'm doing. But if he and I cannot communicate, if he continues to think that I'm not doing a job for him, then I just figured I had to withdraw, Your Honor.
All right. Ms. Schooler, I'm going to go back to you for a moment. I trust that there's been some personal communication between you and Mr. Wood in an attempt to try to reconcile differences on the wording of the journal entry, perhaps a recent phone conversation or email chain or something?
I did call Mr. Wood. I did let him know I was going to have to object because we were still in the process of working out this journal entry. You did order for some documentation to be provided to me by petitioner in regards to picking a vehicle. So I said, hey, get me that. We did not go into the journal entry as much. I did let him know, hey, I made some of the cosmetic corrections, but your objections or your client's objections are, again, more so for reconsideration, and I'm not going to make those changes. And that was after the our Exhibit D, the email including me and Mr. Wood with the disciplinary administrator, where Mr. Presbeal says he is going to file an ethics complaint against me. So not as much as I'm sure the court would prefer, but obviously with this email coming out, I believe Mr. Wood was trying to be as cautious as he could due to the situation.
All right. So the first issue before the court is settlement of the wording of the journal entry in this case. And in doing so, I'm going to try to systematically go through here and determine, is there a legitimate objection to the wording used by Ms. Schooler in what I see as, and I want to make sure everyone's on the same page as to what I'm referring to. In my exhibit notebook, it's Exhibit A, which is what I believe is Ms. Schooler's most recent attempt to draft an appropriate journal entry of judgment and decree of divorce. Is that correct?
Yes, it is, Your Honor.
All right. Obviously, the comma in number 1 has been resolved. Petitioner objects to the court's finding, and the petitioner will not respect the bond of the respondent. Oh, to the extent, apparently, that the petitioner will not respect the bond of the respondent in this matter. If that's consistent with a ruling from the bench, and I think it is, then
Your
that's
Honor,
not objectionable.
may I make a statement?
Mr. Presbeal?
Yes, sir.
So
That's me.
What's your statement?
My concern here is several things in the journal entry are not written how the court ordered. I have recently filed for a transcript request for the judgment in this case. I've paid for that and I have a receipt for it. And a lot of the wording affects the legality of the court's judgment. And when it comes to getting involved with disciplinary administer, I done that because Mr. Woods failed to address our son getting bit by a dog while in his mother's care, failed to address Sydney not showing up for
Okay, we're
exchanges
getting
of
off the
court
path
order
here.
twice.
We're
No,
getting,
sir, we're not.
okay. All right, regarding number 2, the court will overrule any objection to this finding. Mr. Simon's actions in, as I recall, taking possession of the child at a bus stop, that alone gives this court pause and some reason to make a finding that the court has concern that Mr. Perez-Beal will not respect the bond of this child with his mother.
That was during my
And there are other
parenting
reasons.
time.
However, the court finds that the objection is overruled as to number 2. Number 3 apparently has been corrected. As the court recalls, there was a protection from abuse case previously between these parties. The court finds that even though Mr. Perez-Beal may deny that there was ever any abuse by him, court does find that that's an appropriate finding for the court to make. And the court will
Point of
overrule the
order.
objection to number 4. The court also finds that there has been difficulty between these parties based on the evidence to effectively communicate regarding setting a parenting plan or deciding many important matters concerning this child. So the court does
I am
find that there's
submitting all of
evidence
our
in the
text
record.
messages.
All right, if you interrupt one more time, Mr. Perez-Beal, we're going to mute you or take you out of the meeting completely.
Yes, sir.
So the court does find that there's evidence in the record to support that finding of number 5. Objection number 6, objecting to paragraph 13 in the school district should be USD 232.
Your Honor, just so you don't have to pull up the, Google it, USD 232 is DeSoto, Kansas, which is up towards Lenexa.
282.
All right, so number 13.
A lot
West
of the
Schools,
objections-
why is that a problem?
A lot of the objections he made are not what I requested, and I'm getting ready to submit that,
All right.
what I have requested to him.
Okay, I think the children do attend West Elk schools, correct?
Yes.
Yes, sir.
Okay, so what's improper about 13? I
He
don't
has
see any
manipulated
problem
my
there.
objection request.
Okay. I don't think we need to put the USD number in there. I think the term West Elk schools is specific enough. I'll overrule any objection to 13. Number 7 apparently has been corrected, Ms. Schooler.
Yes,
in
it has been.
Paragraph 26.
Yes, I did make that correction.
All right. That appears to be consistent with the orders and rulings of the court as it currently reads. Objection 8. Is there some dispute about the amount of child support to be entered into the record here?
Yes,
Yes.
sir. There's been 3 child support worksheets entered on this without a chance for me to do taxes and submit financial records. And her most recent one states it was filed in, I believe, June 13th
Okay, well,
or May 13th.
okay, wait a minute. Let's back up. Mr. Wood indicated in his objection that I ruled from the bench that I was specifically adopting a particular child support worksheet that called for an amount of $1,383. So why wouldn't that be appropriate, Ms. Schooler?
Your Honor, because you did not adopt a specific worksheet, we imputed Mr. Presbeel's income at 58,000, I think $230. I might be off on the last few dollars, but
320,
he was
58,320.
imputed. Correct. And I had to make the tax adjustments, so there was no actual worksheet adopted because I had to make a change. But he was imputed by you, or his income was ruled upon that it needs to be imputed. So the February 12th worksheet does not have the imputed income because we were never provided that information.
There was never no paperwork filed to omit the previous child support worksheets that were submitted with a file stamp. One of them by Miss Simon herself with a self-litigant form that she submitted with it. And Your Honor, I'm getting ready to file a motion and lay out a lot of things that have gone on here that I believe Miss Schooler and Mr. Woods are discussing and kind of having backroom conversations. Mr. Woods' motion to withdraw on our inability to see eye to eye on this is false. I use a phone recorder, and Mr. Woods previously told me, I believe it was the 10th, that he demanded $7,000, and if I didn't pay, he was gonna withdraw.
All right.
So
Okay,
extortion.
I'm really just focusing on the child support worksheet, one issue at a time. I don't see your proposed worksheet, which calls for that amount. Ms. Guler, it's not, it doesn't appear to be an attachment to your journal entry.
What about the one, the respondent
Okay,
file?
Okay, Mr. Presbeil, be quiet for a moment.
December 20th.
I'm addressing Ms. Guler. The worksheet that you're depending upon to justify your amount in your proposed journal entry, which is a couple $100 a month higher than what Mr. Wood's objection stated it should be. So where is your worksheet?
Your Honor, I believe because that wasn't a legal objection because you already had ordered for his income to be imputed. I didn't include it, but I am going to pull up my notes from the hearing that I have right here.
Well, that worksheet would need to be filed with the decree.
Right. because you had already ordered for his income to be imputed.
True.
And
What the court often does, counsel, is to set the building blocks necessary to put the worksheet together. I hope to always settle those building blocks without determining the actual amount. That really is a mechanical computation. Once you know what to plug in, essentially the worksheet software does it from there. So I don't fault you in all respects here, Ms. Schooler. It's just that whatever worksheet is eventually generated based on the building block orders that this court has made, that needs to be included to support the child support amount, which is in the decree of divorce. But you're telling me that once you had adopted all the income numbers and put all the proper inputs in, it came out at $1,569 a month?
I do believe so, Your Honor. Yes. I'm going to try to find it in what I sent to Mr. Wood.
And I may have adopted certain numbers out of a child support worksheet that had been submitted. But I think if there were any adjustments that needed to be made to the worksheet for any reason, tax exemption adjustments or anything, then I couldn't have settled or finalized the child support number at the hearing.
No,
That's why
you wouldn't have been able to, Your
Requesting a
Honor.
transcript.
Because you will see in the my proposed journal entry, you specifically stated, and I'm going to find that paragraph for you, that his income must be imputed at that number because he had not provided any income information, and you felt that that was a good number for his trade skills, the kind of work that he does.
Imputed at what number?
$58,320.
That's what your child support worksheet says, but it says date submitted May 13th. The one you submitted on February 12th says 13,833. And on the child support worksheet the respondent submitted December 20th of 2023 states where we agree on no child support at all.
Yeah, well,
I'm
none of
all
those
for
past
taking
worksheets
care of
mean a
my
thing right now.
children.
What the court's concerned with was what was presented to the court at the trial and what numbers this court ordered be put into a child support worksheet to generate the eventual child support amount.
Your Honor, it's
I
paragraph
believe it was the
29.
one
Okay,
from
just a minute,
February
Mr.
12th.
Perez-Beal. Again, Ms. Schooler, you have the floor.
Paragraph 29 of my Exhibit A is where I reference you imputing the income, what you imputed at and why you imputed it that way.
All right. Well, again, Ms. Schooler, it's just difficult for the court to adopt a worksheet number when I don't have the worksheet.
I do apologize about that.
But presupposing that you do have a proper child support worksheet, which places the numbers in that was found by this court to be appropriate at time of trial, if that's how it comes out, that's how it comes out. Now, what did you do with the tax exemption benefits, Ms. Schooler?
Your Honor,
What did
he
you
was
contemplate?
given a $203 credit because my client would have been able to claim all 3 children for the year 2024. There is also a daycare cost in the amount of $500 that my client pays. So father was imputed $500 for childcare, and then he was given a complete income tax credit for all 3 children.
Mm-hmm.
On the numbers per age on children, you have 2 children between the ages of 6 and 11 and 1 under the age of 5 or 0 to 5. Right now, at the time of this document, we have 2 ages 0 to 5 and 1 age 6 to 11. And where is the $500 child care? Where can I find that, Miss Gruler?
Your Honor, do you want me to try to sort this out? I just don't want to.
Is it included on the proper line?
Yes, it's in
worksheet?
paragraph G1 on the worksheet.
Okay.
And for the child support guidelines, when the child is over 6 months or close to 6 months, they
what you have.
to the next age group. So I can't control that.
All right. I'm aware of that provision, counsel.
Your Honor, may I have time to file the past 2 years' taxes that a previous attorney told me to wait until this issue was resolved to file my taxes?
No.
Yes, sir.
We're settling today's journal entry based on what was presented and ruled upon at the trial of this matter.
I'm objecting to the journal entry being finalized today.
Well, you can object all you want, but if the court determines that it can settle the journal entry today, it will.
This is a hearing for withdrawal.
We can't just hold up this decree indefinitely because you object to some of the rulings that the court made.
That's why I have requested it. That's why I'm getting the transcript.
What we're trying to do today is properly document the court's rulings. You can disagree with those, Mr. Perez-Beal.
That's what
you may even be able to take further legal action concerning them, but at this juncture, we're just trying to settle the journal entry.
When it comes to on the journal entry,
all right.
Ms. Schuler used a fraudulent witness.
I'm going to tentatively adopt the language in the proposed decree because it is being represented by preparing counsel that she has properly used the numbers that the court ruled upon at the time of the hearing to formulate a worksheet. But without that worksheet before it, this court will reserve an eventual ruling until I see that worksheet as submitted in my queue with the decree. So, Ms. Schooler, it has to be with it.
Absolutely. I apologize. I just wasn't a legal objection, so I just didn't think. I thought we were going to resolve only that. So it will be submitted, of course.
Very well. So I'm going to overrule the general objection in number 8, purporting that I adopted some prior worksheet.
In Your Honor, I can read you my specific notes to you as to the income if you'd like to. Maybe that could jog your memory if you need that.
Well, I didn't attempt to set the child support number correct?
I'm so sorry, Your Honor. He cut you off.
All right. I didn't attempt to adopt a specific child support number, as I recall.
No, Your Honor.
No, Your Honor.
It was subject to further computation and input into the worksheet.
Yes.
Yes.
So the court's going to overrule the objection to the child support worksheet at this time, pending this court's scrutiny of the eventual worksheet submitted to support the number. All right. Number 9. The court finds that the best record is kept by the Kansas Payment Center of systematic child support payments. I do understand the certain benefit that might accrue to Sydney if payments were made directly to her checking account. However, I think that it's important to keep an official public record of payments made. So I'm going to require that the general provision be followed and that payments may be made through the Kansas Payment Center in accord with what we do in the vast majority of all other cases. All right. Objection 10. Child support will terminate for each child after they complete their high school education pursuant to state statute.
Your Honor, I'm in the process of filing a motion and presenting documents to court. I really don't feel comfortable proceeding until the court has had a chance to review.
Okay. Paragraph 35. Isn't that consistent with statutory language, Ms. Schooler?
Yeah, that's what my paragraph 35 says, just more in depth and cites the statute. So I didn't feel like that change would actually hurt the journal entry rather than.
I don't think that there's any inaccuracy there. I see no need for a change. Court will overrule objection number 9, or excuse me, number 10. Okay, number 11 does appear to raise a substantive issue here. Petitioner specifically indicates that the respondent was not awarded the 2003 GMC Sierra. Respondent was given a choice. If she wanted the Sierra, then she would have to take responsibility for the debt, or she could be granted the 2003 Chevy Silverado, and that she hadn't indicated her selection.
The Sierra is a business truck that I use on my taxes, and I was awarded
Sure.
everything regarding the business.
The paragraph's not identified, so where is that, Ms. Schooler?
So that is going to be paragraph 38 and 39.
Okay,
And Your Honor, in Exhibit B, the email where I sent the journal entry, parenting plan and child support worksheet to Mr. Wood, I note that there are a couple highlights within the journal entry because I need to be provided the documentation in regards to the Duramax, so my client can make a decision on which vehicle she wants. I have not received that documentation, and there was an objection about it, but I sent it with highlights saying I need this information, it's subject to change. Once I get the documents, I'll let you know her selection. I haven't received those documents, and this objection was filed.
I submitted all that documentation to my counsel. Let me find it.
all right. I don't see that the 2003 GMC Sierra is addressed in either paragraph. Is that what you're? There are a lot of vehicles involved here, but I don't see a specific reference to a 2003 GMC Sierra.
I think she called it a GMC Duramax.
So I believe it's between the Chevy Silverado and then the GMC Duramax are the two options my client can pick. I think there's one in each paragraph for the time being, but when I submitted those to Mr. Wood, there were highlights on them because I don't know where to put each one yet because she hasn't made a decision because she hasn't received the documentation.
Bottom line is, I was awarded all the property in B&B Construction Services, and that vehicle is used for tax purposes. And you have manipulated the court's ruling, Ms. Schooler. The transcript will prove that. And also, in the
All right. So
notice
Ms.
of
Schooler, I trust that the court order that she had some sort of choice she could make, and she hasn't made the choice?
Because there's debt tied to one of the vehicles, and you said, if you pick this car, you have to take the debt, but I need the documentation reflecting the debt, and I don't have that. So she can't decide, because maybe it's a significant debt. We don't know.
10,000 and something. I submitted that to my counsel. I got a pile of paperwork here. I'm trying to find it.
Mr. Wood, do you have that documentation as to how much this debt is on the GMC Sierra?
And not other than what I put in there, the amount of $10,024.20. But
Where did you get that?
I'm sure I got it off the documentation, but I can look for that, Your Honor. I just don't know that I have it with me right now, but I can send that to him.
If that's the amount of the debt, what would your client's election be then?
I believe she would want to take the vehicle. Is that correct, Ms. Simon?
Yes,
Even though it has that kind of debt on it?
yes.
Okay.
But I just obviously would like to do my due diligence and verify the debt amount. So that's why I was not
Sure.
able to make a selection.
What does it say regarding me being awarded property when it comes to B&B Construction Services? Can you state that, Ms. Schooler?
I'm waiting for Chief Judge Ricke.
All right.
That's getting a little off.
I hate to make you resort to this, but apparently Howard State Bank would be the creditor. May take a business record subpoena, but I think Mr. Wood, if he's got it, he'll turn it over and the court will so direct whether he's allowed to withdraw at the end of this hearing or not. It's just a document in his possession that I believe should be turned over.
I'll look for it, Your Honor, and see if I can find it. If I have it, I'll send it to Ms. Hoover.
That's a very specific number that you stated, Mr. Wood. So I trust that you had some documentation supporting that very specific number.
I guess we could put in the journal entry that, I mean, she'll take that contingent on the debt being that amount. And, or we'll get the records.
Not to
her.
exceed that amount. Yeah.
Yeah, not to exceed that amount.
Yeah. Mhm.
Will the court take notice that Mr. Woods filed a fraudulent claim for his motion to withdraw? And I'm going to prove it. I have audio and a transcript
All
of
right,
it.
well, we'll address that later. We're on the journal entry still. All right, so I think you might have to rename that, Ms. Schooler. If we were talking about it as the Sierra, let's call it the Sierra, and that would be in paragraph 39 awarded to her, along with the debt not to exceed $10,024.20.
Hold on.
I am, Your Honor. I just had to find it.
Then
So
that
she
debt,
would be awarded so the Duramax is the one with the debt. She would be awarded the Duramax so long as she is taking the debt in the amount of $10,024.20.
I say not to exceed that
Hold on. I
amount.
found the document from the bank.
I was saying then that would be entered into her column in paragraph 41 too.
I
Because
can do
right
that.
now you just say, again, if you could refer to it as the Sierra,
Okay.
$10,024.20.
okay. Has there been any payments on it since that number was turned over to Mr. Wood?
No, sir.
Oh, all right, well, it's probably more then. Okay. So most of the wording that's there, presuming your client actually takes the 2003 GMC Sierra and the debt on it, we just need to add that debt to paragraph 41 as hers. And then making that clear in paragraph 39 that she's taking the GMC Sierra and the debt of just over 10,000 that goes along with it.
I can do that.
Okay. And I think
Your
that
Honor,
settle paragraph, objection number 11. Then
I
number
have a
12.
notice of,
Okay, hang on. We're moving on. Paragraph 12. The objection there, he wants to choose his own keepsake items and make his selections through the attorneys. Paragraph
Yeah.
59 reads,
I don't want to be left with scraps. I just want something little from each of our kids. She's already taken most of everything. She lived here whenever I was in jail in Greenwood County, she lived here. And I'm getting ready to prove
all
my
right.
children was taken away from me.
Ms.
That
Schuyler,
emergency motion,
Ms. Schuyler, let me address you regarding that. Now, you have some very specific language regarding what we're going to do about these keepsake items, about the respondent, your client, going through the tub of keepsake items for the minor children and grant some of those to him. Correct?
Yes, Your Honor.
Isn't that consistent with what the court said from the bench?
Yes, it is, Your Honor.
I find that to be, it's imperfect, but generally workable. And I do expect Sydney in good faith to go through these items and split them up in an appropriate way.
Your Honor, if she had
Obviously, the
good
court
faith,
doesn't
she
want to
wouldn't
get
have had her
involved with
father.
every, picture and possible keepsake item. I'm comfortable with the current language.
Can we address the heating and air unit
Um,
and the witness Miss Schuyler brought to court that I have a current no contact order with, that she requested information for a case that was dismissed due to false allegations in that case, missed a discovery I'm going to submit will prove he lied on the stand, and that the court adopted a fraudulent receipt that he claims serial numbers matched. I just got in touch with that company, and I have a written affidavit or email from, I forget his title, but he's a manager at the company, clarifying that the serial numbers on my receipt match the ones that he had on his records.
that's not something that we're taking up right now. I'm moving on with the objection list. I think 13 we've now covered. 14.
The objection list, Your Honor,
properties.
isn't my objection. And I object to this proceeding because it's not what I request.
Okay, well. Okay, why don't you include the legal descriptions?
Because
Your
I was
Honor,
awarded 3
43 and
properties.
44.
Your Honor, he stated that they were provided to me. They weren't. That was going to require me to probably pay to have to get some more records. My clients' names aren't even on any of the properties, so really nothing's going to be changing. I just
Okay.
didn't add them because I didn't have that documentation readily available.
Okay. So he's already the titled owner on Cliff Street and 501 Line Road in Severy,
Yes, Your Honor.
and your client has no interest?
Nope.
Okay.
We
And
just
then
put it
he's
in there to make sure
awarded
all
the
bases.
Turkey Road property, and you did include the legal.
I did, Your Honor.
All right. Since I don't think it's going to necessarily change anything, I'm inclined to agree that I think we can, if you don't have them to insert.
And if he can provide them to me, I'm
Mr.
more than
Wood
willing to
said
add them,
that
but it was
he
going to
would have
require
her sign.
me to pay, my client have to pay to remedy his objection, and I don't feel like that's proper.
All right.
And it says here,
Paragraph
the court
46.
finds that the paragraphs were gifted $40,000. You said yourself that the court acknowledges my grandfather gifted that to me. And then
Okay, we're on the objection to paragraph 46 currently. What's the objection there? That's a standard.
that's what I'm
paragraph.
saying, Your Honor. I'm getting ready to provide the court all my objections and how they were manipulated, and a lot of them not objected to when they clearly.
I see nothing wrong with paragraph 46. I'm going to continue to have that included in the decree. Paragraph 16. Child support worksheet. I know there's some dispute about whether the court's imputed income numbers. However,
We skipped paragraph 48 that I have objections to that weren't submitted.
All right, just a moment. 16. Again, Ms. Schuyler, I'm going to reserve ultimate judgment on the propriety of the child support amount based on the court scrutiny of your worksheet, which I don't have. So at this point, I cannot make a final ruling regarding 16. I trust that you have provided documentation of the child care costs.
I know my client testified to it. I believe I did, but if not, I can absolutely submit it.
All right, please do. 17, object to the permanent parenting plan, joint legal custody should more specific.
And I
Okay,
did make that correction.
all right, fine.
She
So 17 has
submitted
been
Rule
settled.
170 that I was misguided from my client on, or my attorney on. My attorney told me that he needed my objections to this journal entry. And they let Rule 170 slide right past me. And she stated in Rule 170, I believe that the respondent was granted sole legal custody.
That's
Her-
consistent with the court's ruling.
Look at Rule 170 compared to what the journal entry.
I don't know what you're talking about, Mr. Presbill. So,
I'll lay it out for you.
all right. I think the court has ruled on Mr. Wood's objections. Ms. Schuyler, there's some minor modifications that need to be made to the decree before being submitted.
Can we address paragraph 48 for a minute?
All right. What would be wrong with neither party shall post sexually suggestive photographs or videos on social media or the internet? What's wrong with that?
Nothing, because I didn't object to it.
I thought you just said you wanted to address paragraph 48.
I'm on the journal entry of judgment and decree of divorce.
That's what I'm looking at.
Okay, maybe I had some paperwork. 44, I'm sorry. I stapled my papers wrong.
It's an award, making certain findings.
It states in there, F, respondent shall receive no less than $11,000 with their accrued judgment interest and up to 1/2 of the total proceeds of the sale of the real property. I feel like the wording has been manipulated there to override your ruling. You said that I was awarded the property and that I had until August 31st to pay that $11,000. And I'm willing to pay it in full once this journal entry is finalized.
Okay, so what's the problem if you intend to pay it off?
Ruling.
Excuse me.
Because the wording in there, her wording in there says that the client is still entitled to half the price of the property.
No, it's either or. If
F.
you pay it off 11,000 plus interest by the August 31 deadline, then there's no purpose at that point to the language regarding sale, because the sale wouldn't be necessary at that point.
What's keeping if you retire in a couple years, what's keeping them from bringing this journal entry before another judge that didn't make that judgment and has no idea what's going on? They just have this wording to go by. This wording in paragraph F states that the respondent gets $11,000 and half the price of the property.
Your Honor, what I think would help is if I indent D, E, F, G, so it shows that it's falling under the August 31st to discharge the lien, because D says if he fails to do so, I can indent it so it shows what happens if that August 31st deadline is not met. I think that would make it a little more clear. I don't mind doing that.
It wouldn't hurt if you'll make that change.
Absolutely.
So there's two options there. By August 31, he can pay 11,000 plus accrued interest and buy her out. He can do
Can
whatever he wants
you
with his property at
clarify
that
to
point.
me,
But if he doesn't pay it off by that date, then it goes to the sale provision.
or buy her out? What do you mean by that?
I think
You
the wording is
stated-
fairly obvious.
You stated that I give her $11,000 and I'm awarded the
Plus,
property.
plus interest. Yes, that's correct. If you
So-
get it done by August 31st.
Yeah, okay.
Correct. Okay. So the real question that remains before this court is Mr. Wood's involvement in the finalization of this journal entry. This court's point of view at this juncture would be that I think it's a professional responsibility that was previously imposed on this lawyer to sign off on what this court believes to be an accurate reflection of the court's rulings. Ms. Schooler, I trust you can address this relatively quickly.
Yes, Your Honor, I'll do it right now. The only reason for my objecting was I need that documentation, and based off of Mr. Presby's email, I don't
Okay.
think it would be best for me to
Right.
have direct.
Here's something else that I'm going to ask you to
I
add.
want to wait until we have the transcript.
All right. Ms. Schooler, I want you to add a paragraph at the end of this journal entry that says that effective upon the filing of this journal entry and decree of divorce, Ronald P. Wood is withdrawn as counsel for the petitioner. But I do want Mr. Wood's signature on the document. It does not require, in this instance, Ms. Schooler, the signature of either one of the parties. So take
How
that
can
off.
you say that?
The journal entry is just meant to be a reflection of the rulings of the court. The attorneys have the authority to sign off on that. And the parties themselves just flow up the process. So
This is our divorce and I'm not agreeing. That's a
Ms.
contract and I have to agree to it.
can you give me some realistic appraisal as to when you can get this to Mr. Wood?
I will work on it right now, Your Honor. I can probably have it
Today,
to him
then?
in 30 minutes.
Because I would love to have this in my signature queue by tomorrow.
I will have it to him in
Today, even.
30 to 45 minutes. I just want clarification. Am I removing the party signature lines from the parenting plan as well?
You are. Oh, yes, because that's a
Is that
forward
legal?
parenting plan and not an agreed upon parenting plan.
Yes, Your Honor.
Is that
Yes.
legal?
Yes.
Your
And,
Honor.
and your child support worksheet will need to require this court specific approval.
Yes, Your Honor.
Okay.
Your Honor, can you
So that'll be
legally do
submitted in the
that?
queue for separate approval. But along with the decree. Any questions
will-
about that, Ms. Schooler?
No, Your Honor, I will have it to him shortly.
Okay. And then, Mr. Wood, if the journal entry that upon your approval of the wording that I think the court has settled today, when you put your signature on it, that and allowing you to withdraw as soon as the court approves thereafter, are you satisfied with that resolution?
Yes, Your Honor.
All right.
You just said that Mr. Wood, no attorney's signature has to be on that journal entry.
No, I say yours doesn't have to be on there. Nor does Sydney Simons. All
Well,
right.
let it be on the record that I'm firing him. He don't represent me.
Court's already made its ruling. He's responsible for signing off as counsel of record as to what happened at the time of trial. Then he'll be allowed to withdraw at that juncture.
How does the court respond to him not? He didn't, Your Honor, a lot of my objections were manipulated
Well,
to make my objections sound stupid and invalid.
if you believe that you should have appropriate legal remedies in this case, following the finalization of this decree, I suggest that you get legal advice from a new attorney and follow that attorney's advice.
Are you going to
That would be
take
my
any
suggestion.
disciplinary actions into him filing a false motion to withdraw?
I don't know how you can call his motion withdraw false.
Because I'm gonna supply with the court a transcript and then audio of him trying to extort money from me and saying that if you don't pay, I'm gonna have to withdraw, and then turning around and filing it for what he did.
All
Your Honor,
right.
I said in the motion to withdraw that we had a difference of opinion in the matter, and we do still have a difference of opinion. And as far as appropriate course of action going forward, we disagree on that also. Those are the reasons is,
Yes,
Your
which are
Honor, what are,
legitimate reasons to seek withdrawal.
Mr. Woods, what are you gonna say when you find yourself in court having to testify to our phone conversation?
All right, well,
It
we're not
is
going to
what
get
it
into
is.
that. All right, Ms. Schooler, I think you have all the direction from the court that's necessary to finalize the journal entry and decree of divorce and child support worksheet. Is that
I do.
correct?
Yes.
Your Honor, are you just gonna overlook that Miss Schooler had a witness lie on the stand in your courtroom?
That is not an issue before the court at this time.
It is. I objected to it, but it was not submitted.
All right. The court's rulings made from the bench in Elk County stand with the clarification orders made by the court on the wording of the journal entry and decree of divorce. So I think, counsel, that essentially addresses the issues that need to be addressed. And therefore, at this time, this proceeding is currently in recess. I will look forward, Ms. Schooler, to receiving the journal entry, decree of divorce, and new child support worksheet and parenting plan here shortly, perhaps even today. Greatly
It'll be in
appreciated.
Mr. Wood's hands after 45 minutes, so just
All
don't
right.
hold that over me.
Let's get this wrapped up as soon as possible.
Okay.
All right.
Thank you, Your Honor.
All right. If there's nothing further, then this matter is currently in recess. The meeting may be ended for all.
Okay, on Harold Hughes,
With that,
we ready?
Certainly, John.
Let's come on up.
Custody. Was back to Mr. Williams. He was on the initial docket, so it's okay to reset that change in the big picture of things.
Yeah. Ms. Williams, reset it for announcement, but he needs to get a resetting on Williams. Thanks for coming over. It's been chaos over here, but
No,
it's another day in this court.
Was that something?
absolutely not.
Did you see the judge's bobblehead off?
I did not. Thinking of the chair, he's hiding it.
He's keeping it close.
These are all
Administrative.
administrative or ministerial.
Yeah.
Do we have money still left to pay out of this?
Yeah,
Oh,
Someone's gonna say
Lotsky.
there is, are you referring to just restitution? $400,
How much?
$400, the amount due is $5. So someone came and made a payment. There was an original amount of 700. They made a payment of 300 in the last few days. Maybe on the 12th, I believe. And then, so that leaves a balance of $400. But technically, right now, what is due is $5.
It's
$5 on the restitution.
because he's paying in installments.
Right, correct.
Okay. There is in 23 CR 1012 Harold Randall Hughes. That's you, sir?
Yes, sir.
You were here with Mr. West, your attorney, and the state's attorney. Hey, raise your right hand, sir. Do you solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. There's a motion to revoke probation that was filed on August 1st of last year, and we need to move forward on that. Does the defendant waive a formal reading of this? Can we proceed in summary?
Yes,
Mr.
sir.
West.
Yes.
In summary, sir, this motion to revoke probation states that on November 13th, 2023, in this court, you were sentenced to 2 years in the state jail. That was probated for 5 years for forgery, for the forgery of a financial instrument, a state jail felony. Is all of that true?
Yes, sir.
Allegation 1 states you failed to report to the Jefferson County Probation Office for the dates of May 9th and May 30th of 2024. Is that true or untrue?
Yes, sir.
You can explain a little bit. Is this true or not true? Now, the most I make explain.
Yes, sir. It is true.
Number 2 states you failed to provide verification of performing community service hours as required. Is that true or untrue?
Yes, sir.
And then finally, the states you have failed to pay court assessed fees as directed as of July 17th last year. This states you were $960 in arrears. Right now, what is the arrearage?
$1,980.
Yeah, those things never end. But the important thing is restitution is still owed in the approximate amount of $400. And that's what's important to this court. When can that be paid, do you think?
As soon as I get out, Your Honor.
Like
2
the
weeks.
day you get out?
Yes, sir. 2 weeks.
Well, I don't want to say the day he gets out. I'll give him a little time, but
Okay, so you understand what you're charged with in each of these, and you're pleading true or stating it is true on allegations 2, failing to provide verification of performing community service, and then the arrearage. Were you able to pay? Are you paying as much as you can?
Your Honor, he has been in custody at the GIST.
I know, but there's still people in custody and then people on their behalf. Or are you paying as much as you can?
Yes, sir.
Okay, that's all that's
Yeah,
important.
his
Yes,
mother's
Your
been
Honor.
paying.
Right. Failing to report here on May 9th and May 30th of 2024. What's that all about?
Your Honor, he was after he got placed on probation here, he was out on probation, had checked in a few times with the probation department, was getting going on probation, and then his bond out of Orange got revoked. He had a case over in Orange. He went over to Orange, and then they eventually sentenced him 1 year state jail. That's why he went to GIST, and then they were brought after he got
When
to
did,
GIST.
I mean, was that during May 9th and May 30th when he should have been reporting?
Yes,
Yeah.
Your Honor.
And then
Do we know that for sure?
No,
Okay.
we
well,
were relying
you can't-
upon defense counsel to
and
Well,
we-
I mean, he can't be in jail and also out reporting at the same time. That's impossible. Then that's a defense if he is in jail.
I want to repeat, Judge, whenever we were here earlier this week, counsel made this claim. It was reset for him to bring proof about the
What do we
time
have
that
on
he
that?
was in custody. If that has not been done, I'm not prepared to move forward. I don't want to go forward on mere accusations that this
Oh.
man makes. I was told that there would be proof about at the time he was in custody.
Yeah.
Your Honor, we
I mean, he's on probation for forgery. We're gonna make sure to verify
Yeah.
everything.
Your Honor, I should be able to get that document today. We've been working on with the GIST unit to get some kind of proof. Apparently, that supposedly, whenever he was sent to the jail, they should have released that to the jail, but I have not been able to get a copy of that.
What are we gonna do today?
Today, I would request if we get this document and by the end of the day, and I'm working, like I said, I've been working on trying to get them to give me something, email me something. My request is to continue on probation because if he was in GIST jail, which I have no reason to doubt that he was in jail, because that's where they went and got him from our jail, got him from there. Then let him on probation and come back in 3 months to see if he's made progress on making payments now that he's out and can do that, and see if he's done his community service. Because right now the allegations are issues where if he was in jail, he couldn't do this stuff.
Okay.
So
I'm going to have to
There's a
make
way to
some
avoid all of
comments, because when we were here, initially I was told earlier this week that he never was released, that he never had an opportunity to report. I got with the probation officer, and the facts is that he did report on 2 different occasions. I advised defense counsel about that. The burden then shifted to counsel to provide proof about the accusations they were making. Again, we're standing here, the probation officer and I, because it was set this morning. So I was under the impression that we would have that information. Now we're being told we don't have it. We'll get it later. I've not made any attempts to do my own independent research because I wasn't even aware that it was on the docket today.
Don't mean to keep him in jail, but I'm gonna do that until you do
Let's
it.
get us, if we can go to the jury room and make some phone calls with him, he has to verify.
Look,
I can't
I'm
get-
not doing it. Y'all have to.
But I say, if you give me the, I know there's
Please.
issues about going to the jury room. If I can have some time in the jury room with them, I know there's stuff happening earlier this week. Give me about 10 minutes. I should be able to make some phone calls and get some email to the court.
Okay,
But if you, I don't want to walk away from the court. If the court says we can excuse, we're going to do that right now.
yeah,
Okay, let's go.
okay. All parties are present here in cause number 23 CR 1490, the state of Texas versus Joshua Booker. State of Texas, the defense attorney is in this hearing via Zoom. All right, what is it that the defense is asking for here at this late date?
Yes, Your Honor. So we're asking for an independent DNA test, and we didn't request it before because we were under the impression that the state was going to conduct a second one. And I'm not, and I have a duty of candor with the court. I'm cognizant of the fact that typically when there's second or independent DNA tests, you've got a situation where there are potential multiple contributors to a surface or something of that nature, and we're not dealing with the paternity test. Mr. Booker has maintained throughout the pendency of this matter that the DNA test, that there had to be some problem with it, that he is not the father of the child born to Malaja Davis, daughter of Danielle Davis. This case is set for trial on Monday to begin. And Judge, just a little bit of history. So the originally, the person who did the initial analysis didn't work for the same lab anymore. So back in January, this case was reset with the understanding that there was going to be some additional DNA testing conducted. However, the state has since been able not only to have a second expert analyze the raw data and be prepared to testify, but I was informed yesterday, shortly after filing this, that indeed the original analyst will be present to testify about the comparison and extraction that was conducted in this matter, Judge. And I have to tell you as well that I'm not aware of any quality of service matters arising at the lab during the period of time where this sample was tested. Nonetheless, it is my client's assertion that the DNA test that was originally done is somehow not reliable. He asserts that there had to be some sort of cross-contamination of some sort, and therefore is requesting a second independent test, Judge.
Your Honor, I would argue that number one, it's untimely. They've had plenty of time to test this on their own if they would like to have done that. Also, the lab that tested this is Endeavor Laboratories in El Paso, Texas. Beaumont Occupational Services is the only person I know around here that does the paternity testing, and they send all of their testing out to Endeavor Labs to perform the actual analysis and the testing on the DNA material. They would still send, and it's my understanding that if Mr. Wilkerson were to use somebody, it would be that same Beaumont Occupational Services. So it would be tested by the same lab, by 3 of the same analysts who tested this stuff initially. And there's also a paternity order where he has been ordered and deemed the father of the victim's child in this case, that the 12-year-old victim that was impregnated. There's again nothing to suggest. Also spoke with Mr. Daniel Slawinski at the lab. There's been no testing analysis. It hasn't been updated anyway. It's not any more accurate than it was in 2023 when this testing was performed. He advised me that it would be the same exact testing that would be performed that they performed for this test. There's no, updates in science or that's going to make it any more accurate or any better than what it was back in 2023 when it was tested. There aren't unknown individuals. The defendant was swabbed by Detective Frank Coffin here at the Beaumont PD, and the victim, as well as her child that she had as a result of the defendant. Swabs were taken of those as well, all sent to Bowman Occupational Services, which were then sent to Endeavor Laboratories, where they were tested against each other, and it found that he was the father to the exclusion of 99.9% percent of everyone else. So this is, I don't see how in any way the analysis here is going to be tested any better. It's going to be tested by the same exact lab, the same exact analyst, barring one. And we have all those individuals ready to testify in this trial. We've already prepared. We've got flights scheduled for all these individuals, as well as hotels. And this individual's had, the entire time that the defense attorney's been on this, that if he really wanted this tested, he could have had it independently tested up to this point. I would argue that it's, again, that it's untimely, and kind of looking at Anderson v. State, that's 301 Southwest 3D 276, Texas Criminal Appeals, a 2009 case. And that's where essentially suggested that the court did not err. Yes, Your Honor. And he said the essentially, though the motion itself was not filed in compliance with the rules, they said even if that were not so, the fact that it was so untimely, being filed at the last minute, that they would not it would not change things as far as that. So they again upheld where a chemist did not test, I believe it was the drugs in that case.
Judge, the only response I have to the timeliness factor, and this is all on the record from the January appearance, that is the appearance where the state indeed represented to the court. And so the defendant was under the impression that a second DNA test was going to be conducted. And so, that in terms of deciding this on the grounds of timeliness, it's not that the defendant didn't assert this claim. It's that we were under the impression, of course, that secondary testing would be done. And so as preparations for the trial had begun is when, the additional circumstance, indeed, the now,
What about
like
that?
I said, I was just told yesterday that the original analyst will be able to testify in the case. So, and that was new information to me, Judge. And so, I've been candid with the court regarding the issues or perspective lack thereof. I would just ask your Honor for an opportunity for before the court makes a ruling for my client to make any request or statement on the record as to why he believes or why he feels this testing should be conducted before the court issues a ruling on the matter.
You can't speak for him? Well, you've talked to him. What his story is going to be. What's his contention?
As I've already represented to the court, Judge, it's that the DNA test, that there has to be some sort of error, cross-contamination, because he asserts again that he is not the father of the child.
And Judge, we did not perform the only reason for the testing was not any kind of, there's no question as to the validity of the testing and the results. It was simply because we didn't think we'd have the analyst here. We also found case law, which Mr. Wilkerson is aware of well before this, that allows an independent analyst to review the raw data there and come to their own conclusions on that and to allow them to testify to that. And Mr. Wilkerson was aware that we were going to use the quality control manager there, who's also an analyst, to review the raw data and come to his own conclusion, as well as having one of those original analysts. We were able to locate the other two as well and to get those. And so we weren't going to perform the testing from the time we know that we have the other analyst, that he's allowed to review the raw data and testify to that. It just so happens we happen to get the other analyst as well. And Mr. Wilkerson had a trial well before this that he knew that we could essentially do that, use the, and it was held next door as well, that that was allowed for the other analysts to review the raw data.
What about that?
I mean, it is true that there was a trial next door and there was an objection that was lodged by the defense to an analyst testifying regarding the DNA comparison, and case law was located and presented that indeed that analyst could give that testimony so long as the raw data was analyzed and not just a report from a different expert. And so, yes, at that time, the defense became aware that they would not have to use the original analyst.
Okay. So what are you asking for?
Your Honor, we're asking that the court allow the Beaumont Occupational to come out to swab the defendant and run send to Endeavor or the provider that they utilize, since Beaumont Occupational, to my knowledge, is the only one in the area performing the analysis. I did not contact LabCorp. Beaumont Occupational is who I have listed in the pleadings. And so in terms of a secondary independent analysis, that's the relief we're requesting, Your Honor.
Okay, what's your contention about that? What is your contention? Why is that relevant in this case? Why would that be relevant?
Your Honor, again, the allegation or assertion is just that there had to be some sort of cross-contamination when the trays were either amplified or tested directly.
No, who says that? What expert?
No, I Judge, there's not an independent expert here. Again, the issue is that the defendant alleges that the test is inaccurate and wanted secondary testing. So,
all right, I understand. I think but look, that's when they put the people on the stand to testify, that's what cross-examination is all about, right? It's to question the veracity and the strength of the testimony. That's what's done. That's why cross-examination was invented thousands of years ago, to test the credibility of witnesses. It's the greatest test, that's said. Here, what you're saying is that with this same argument, anybody on the planet can at the last minute come forward and say, I just want another test. And it's not for anything other than, I believe there might be some cross-contamination, which is tested, every case is tested in DNA like this in the same way. Is that somebody makes the test, then the defense has an opportunity in preparation to review those matters, and then at trial, cross-examination is made. But here, saying they didn't do the test right, that is not satisfied. That another test doesn't satisfy that answer. That doesn't change the equation. That doesn't mean anything. That doesn't contest that procedural issue that you're asking for. That's why they put on the experts who did the analysis testify, then the defense cross-examines. That's what's done in every trial like this in experts. It's not something, well, we're at the eve of trial and we don't believe the analysis was done properly. Really? Where does that guarantee you an independent test on that, just because you state on the defendant's behalf he doesn't believe it was done right.
And Your Honor, again, you know, if there were any quality of service issues that I could present to the court, I happily would. I'm not aware of any.
Okay, well, that's why this is done at cross-examination. That's the proper place for it. And just saying by whim, I just don't think it was done right, is not going to open the door to independent testing. Not on this court's watch. And unless you can get me a case that says that's all it takes, it's not without defense. The defense is in the scrutiny of the defense during the testimony at the trial of how it was done. Did it follow procedures? Then the jury makes the call whether they believe there's evidence to show that the test was not reliable. That's the reliability. It's the reliability issue. But by whim, just say, I want another test because I don't believe it was done right, doesn't get across the finish line. It's not, you're not without a defense. You're not without the ability to question things and scrutinize it. You're going to be given ample opportunity to do that. And the jury makes the decision of how much weight and credibility to give to all evidence and testimony at a trial. We're not going to change they're the fact finders. They're the ones that make the call. But at the last minute to after this case has been languishing here for a while, what is it?
It's about little over a year old, Judge, or a little over a year old on my watch anyway, I should say.
It was indicted September of 23, sir.
Okay. And yeah, I believe I was appointed in May of 24, I believe.
Over 20 months. And then on the last workday before the Monday trial specially set on this, by just the reason I don't believe the test was done right. I want to redo everything and have independent DNA testing. The court doesn't have anything before it that shows that is an automatic right. And without better cause than what you have suggested, the court does not see that it's necessary, and it is going to be taken care of by thorough cross-examination and arguments of the defense and the scrutiny at trial of the methodology used in the testing.
I understand, Your Honor. As the court's aware, I have a responsibility to my client, and he advised he wanted to pursue a second test, and so
I meant it. You have raised things. You have to vigorously represent your client, and that's important. You're entitled to do it, but the court is going to does not grant all decisions, and doesn't grant all requests. And in these circumstances, the court finds that it is not. It is unnecessary for a proper defense. We open the door. We would be retesting every scientific methodology used along the way, and that is not what the law says is required. Is all tests must have an independent testing done for questioning. That's why the people are under oath presenting the evidence. They are cross-examined, and the jury makes the call on how much weight and credibility to give. That's where that is the proper place. This court finds is the test, and where the defense efforts are to be in this particular set of circumstances, not independent testing at under these circumstances. I don't find that that's not the answer to this, that they didn't handle something correctly, or that the steps along the way were not performed correctly. An independent, that doesn't open the door for an independent evaluation of this the item, the evidentiary item at issue. And the state has the burden of proof to convince the jury that it was done right anyway. So they're the ones with having to climb the mountain
Excuse me.
if they can. Anything else? That is all.
Noted.
Your Honor, I would just note that the Attorney General's office relied on the same test. They didn't test it. Again, they relied on this to determine the paternity and the CPS case as well.
Did you understand that to be a fact?
Yes, sir. Yes, sir. I obviously I don't represent Mr. Booker in those matters, but it is my understanding that there was an adjudication of parentage based on the testing that was conducted in conjunction with this case.
Okay. Was there anything that independent evaluation saw, or anything suggesting that this testing that you're at issue over was not valid in any way?
There were no issues of any nature of that nature raised in conjunction with the paternity determination, Your Honor, in the family court in the CPS case.
And who did the evaluations on those, or the determination? Did you say that's general?
Well, there was not other testing. They just reviewed this report. They based it off of this, so they didn't do duplicate testing, having to waste state resources on that. But I'll have to see.
Wait a minute, but okay.
Yes.
But they didn't, there was no indication that there was anything inappropriate or questioning the validity of the results.
That's correct, Your Honor. That's what my understanding, speaking with CPS on this. Yes.
Okay. It's there again is, if this were the way it should be, then their analysis needs to be independently attested. And that's not independently examined. And that's not the way it works. It's the fact finder will make the decision on accepted, valid testing. And the issue that you're suggesting is the manner and means in which it was evaluated by the testing authority. And that's what for a jury to decide after they hear all the evidence, including cross-examination by the judge. All right, your request is denied for those reasons. Thank you. All right, what do we have next, John?
Yes.
Harold Hughes?
Yes, sir.
Hey,
John.
welcome. All right, let's get to this. Since we're about to go into our afternoon docket, this is so, this really took way too long, folks. All right, what are we going to do? There's a motion to revoke probation here.
I'm going to dismiss the motion. He just handed me that he was in jail for a year.
Sir?
Yeah, I just gave him the document that he was in jail for a year and actually 3 months.
Oh, okay. So
it's 15 months actually. He was in jail.
all right, send me a dismissal and we'll sign it.
Yes, ma'am. Thank you. God bless you. Up soon. Thank you.
You want to say anything?
Thank you, Your Honor.
Oh,
Thank
no,
you.
I mean,
Oh,
you didn't, you know, you got the good, you're rolling in the right track. So what are you going to do next?
I'm gonna get a good job and raise myself.
How old is he?
Now,
Good. Well,
Good to.
what's the best gift you can give to your child?
be in his life.
Well, how about living a good example?
So,
Your child is going to do what you are. They have a natural tendency to emulate their parents. So live a good example so that your child will have a good life. Okay. Thank you.
Your
for
Honor,
that.
getting paperwork.
Oh, yeah, you got all the paperwork you want, but get your lawyer to, hey, John, he's talking about, he needs some copies of paperwork. Have you talked to him about whatever he needs?
It's out and we can, well,
Okay,
yeah.
thank you. We're in recess.
And so, this is my own concern, they needed Mr. Morrow, so.
Oh, they did.
That's all on the record, matter of, we're recalling that of the city of bypass is Jeffrey Morrow, 25780. Council, your items, please.
Your Honor, Richard P. Serrano, P3382.
Hold on, Mr. Morrow. With my client presently in custody in the Wayne County Jail. Now state your name, please, Mr. Morrow.
Pardon?
Your name, please, Mr. Morrow.
Jeffrey Del Muro. Jeffrey Del Muro.
Okay, thank you. Good morning. All right, council, today's date scheduled for the pre-trial on this matter.
That's correct, Your Honor. My client is continues.
Yeah, I was just drinking vodka.
Hang on, Mr. Morrow. Hang on.
Hell,
Just wait.
Mr. Morrow, please.
yes, ma'am.
Not interrupt while your attorney is speaking, okay?
Yeah.
Your Honor, he's going to go speak continuously since this matter. And Your Honor, he is going to plead guilty as charged. One count of public intoxication. I've advised him of his rights. If he understands it, and Your Honor, we're ready to go forward with the plea.
Okay. Mr. Morrow, I need you to please put your hands.
Yes, sit down.
You solemnly swear or affirm the testimony you're about to give in this matter be the truth?
Yes, ma'am, I will do. I will tell you the truth. I promise I will.
Okay. Sir, as to the charge of public intoxication, how do you plead? Guilty or not guilty?
Guilty. I was just drinking I half a pint of vodka and the police came. I didn't have no drugs or nothing.
Okay. And sir, you understand all of your rights, and you've been able to go over those rights with your attorney, correct?
Yeah.
Can you understand the possible penalty as a result of your plea?
Okay.
You understand, sir, that this court can sentence you to jail, probation, or fines and costs, or a combination of all that. Do you understand that?
I got some. If I get a fine, I can pay someone. I got some money in my account.
Okay. Sir, I just want to understand, I just want to know that you understand the possible penalty.
Yes, I do, man. It's
right.
just we're drinking vodka. I only have vodka.
Okay.
I didn't have no drugs, you know.
Okay. And
Don't get it serious in your court.
has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
I'm pleading just guilty. I was just drinking the vodka. That's all I was doing.
I understand that, sir. Did anybody promise you anything or threaten you for you to plead today?
No.
Okay.
Nobody.
Any immigration issues?
Your
Okay, counsel, if you can please go to your client. Oh, I think that
He's pretty much sound himself.
Yes.
I would briefly go over.
Except you didn't say where he was at.
All right, Mr. Morrow, can you hear me?
Yes, I do.
Great, I'm your lawyer, Richard Serrato. Remember we talked, were you in a public park at the time that you were drinking the alcohol?
In a public park?
Or in a public place, let's put it that way.
No, it wasn't a public place. I was sitting on a lawn by the stop sign.
All right, that was outside. It was outside, right, in the city of White.
Yeah, it was outside. It wasn't inside.
Okay, and it was open to the public. Is that correct?
Yeah, it was on a lawn by the stop sign. I was waiting on the bus.
And you were drinking alcoholic beverages. Is that correct?
Just a small bottle of vodka. It was just a half a pint.
All
I
right.
didn't have no drugs.
You were intoxicated from that vodka. Is that correct?
No, not. I only took a few couple sips.
All right.
I took about 4 drinks of it so far when the officer pulled up.
Okay, hang on. I'm satisfied.
All right, the court has also satisfied the plea as knowing, voluntary, and factually accurate. The court will accept the plea to the charge. And counsel, yes, for immediate sentencing.
Yes, Your Honor. Even the prosecutor has recommended time served. I've told my client that's only a recommendation like I'm making.
Yeah, I got a job. I'm working, you know.
The answer, it was a small amount of alcohol, as he said. He was cooperative with the police, Your Honor. We would have. He's really handled.
We're doing it.
Okay, so here's the thing, Mr. Morrow.
Yeah.
Mr. Morrow's criminal history dates back to 1976. So we're about 40 years. A lot of criminal history. And a lot of that involves your client's alcohol consumption. And so,
Shut your goddamn up.
Mr. Morrow, I need you to please not interrupt me. Mr. Morrow, I need you to please not interrupt me. And so the court is quite familiar with Mr. Morrow, and Mr. Morrow has been here a number of times for very similar matters. And Mr. Morrow
Haven't been no trouble in a long time. I just was drinking vodka. I was waiting on the bus, and the police someone saw the vodka and they called the Wyandotte police. When they came, they dumped it out. They just brought me here. I've been in about 6 days, 5 days.
I will say, sir, you went almost 2 years.
Yeah, I've been no trouble in that long. I've been here a long time. Been looking for a job, you know. I got some money with me for the fine, you know.
Okay,
Stop talking, Mr. Morrow.
sir, actually, you were just here in February.
I was, or I wasn't. I don't remember. I can't remember.
But I'm reminding you because I'm looking at it right here. And this
Oh, okay.
represents you 90 days jail credit for 10 days. And then we were released, presumably sometime April or May. And then here we are in the beginning of June. And you're right that, yeah, exact same reason why you were just in custody. So,
I wasn't really intoxicated. I just had like 4 drinks of the vodka. That's all I had.
okay,
And then the police brought up and they dumped the rest out.
Mr. Morrow,
Yeah,
you do not really agree very well.
I can't hear you.
You and alcohol do not agree very well, it appears.
Oh, okay.
But yet you're continuing to use it, sir, to your detriment.
I haven't took no drugs. I haven't been on no drugs.
So here's what the court's going to do. The court's going to order 60 days on the alcohol tether.
Okay. 6 days, Kevin.
60 days on the alcohol tether to the Wayne County Jail.
I gotta go back there.
Sir, no, you're already there. You're going to be able to be released
Okay.
as long as you have an alcohol tether to the Wayne County Jail.
Okay.
To also order 11 days jail credit for 11 days. Sir, if you consume any alcohol while you're on this alcohol tether, you will be arrested and serve the balance of that in the Wayne County Jail. Okay?
Okay.
$200 fine, $200 cost.
Okay.
You have $75. Justice system assesses you have $50.
Okay.
Your Honor, my client's not working.
The court's going to waive that.
Waive the fines and costs, Your Honor?
Yes.
Thank you very much.
All right, thank you. Have a good day. Have a good day, Mr. Morrow.
Okay, thank you, man.
All right, and we are recalling the matters of the city of Melvindale versus Karen Frederick and the city of Melvindale versus Diane Betts. All right, we're going to have the record of the matter of Ariana Perez, 24627.
Attorney Corey Westmoreland, appearing on behalf of Ms. Perez. Ms. Perez, and please state your name for the record.
Yes, we have to be able to record all of the proceedings, and so your quiet voice is not going to work so well for that. So even if you feel like you're yelling, yell away. All right, thank you. All right, and so today's date scheduled for probation violation in this matter. Ms. Perez was. There's a lot going on in this Perez. All right. So she already pled guilty to the probation violation on April 9th of 25. Ms. Perez is on probation for operating while intoxicated as a minor. As a result of her plea to the probation violation, she was referred to the treatment court. However, she was contacted numerous times. So I'm going to walk over there. Outreach attempts were made on April 29th, April 30th, May 5th, May 7th, via phone and email. She also received a notice to appear for a lawful appointment on May 13th. It was mailed May 7th. She didn't appear for that. She got returned any outreach from the Regional Wellness Recovery Program, so she's no longer eligible to participate in that program. So we're here for sentencing on her plea of guilty to the probation violations. And counsel?
Yes, sir. So is she here for violation of probation today?
sentencing on probation. So she pled
Okay.
guilty already.
Okay, that's what I didn't understand.
She pled guilty back in April. We
Okay.
did not, and we referred her to the treatment court for after sentencing, she was interested in the treatment court.
But
Since she didn't appear or return any contacts for outreach, we're here for this, we're sentencing her.
sure, and I guess I would just be asking for one last opportunity for the treatment court. Ms. Perez did indicate to me that she was at an all-time low. She did check herself into a crisis center. She was then hit by a car, but she is involved in weekly therapy at this point already. She just started working this week as well, so she has done a lot of good things to get her life on track. She's just asking for an opportunity to show us how to court that.
When were you hit by a car, ma'am?
It was last Tuesday. Me and my friends were on Stewart and Monroe Street, and a car we had a green light. The car turned in front of us, and we had a direct hit with it, and then directly in my side.
Oh, so you were a car accident, you weren't a pedestrian hit by a car.
Oh no!
Okay.
From there, I had to go to the ER, and I had my X-rays and CT scans, but I just have a lot of bruising around this area.
Okay. Well, here's part of the concern is that your client was sentenced October of 2004. And the maximum that she could be under this court's jurisdiction after sentencing is 24 months.
Right.
So we're already 9 months in. So it was already a tight time frame for your client to be able to participate in the treatment court because she had already been sentenced in October. So I'm not sure if she has the time for the program to be able to do that. However, what I will do is I will give you one last opportunity now. You have to appear here by Tuesday, June 24th.
What time's that, Judge?
I'm going to say 10 a.m. I'm not sure what Miss Courtney's schedule is at this point. She's not in the office right now. So I'm going to indicate June 24th at 10 a.m. If you do not show up, ma'am, it's off the table completely. Not even a consideration.
Thank you, Judge.
All right. And then what I'll do then, if your client shows if your client shows up at 10 a.m. on Tuesday, counsel, you're already going to be on we don't have a docket Tuesday. But can you zoom in on Wednesday at all, counsel? That's right.
Oh, no. That morning is,
Yeah.
I could the 24th. I'm just the 33rd.
Yeah, no, no, we don't have a docket on my afternoon was already, I have meetings all day on Tuesday the 24th.
I could July 2nd. Yeah, I'll be out of town, but I need to zoom in.
As long as you're not zooming in from the water, that's for sure.
Put it background.
What about the 26th?
I'm in Oakland County Circuit.
What time you start that?
Depends, you know, if you get caught behind jailers and everything, it's,
Um,
and then I'm in Hazel Park in the afternoon. Stop right.
okay. Right now, we're gonna do Tuesday, the 24th at 10 a.m.
I could zoom.
Bring a client to appear. No, not for that. And then we'll determine the next steps at that point.
Okay.
Okay. So. I don't know how we put it in the system, but I'll figure it out. I'll just keep this right here so I can figure out how to do this.
Thank you.
Okay. If you're just right now, now in your system.
The only way to put it present, and that's what.
Okay, and how are you doing?
With the help of the antidepressant, they have me on a antidepressant and an anxiety pill, and I think so far it's helping me a lot.
Okay, good. Glad to hear that. Okay. All right. All right. We'll see. Well, you'll make sure you're here on the 24th, and then council and Ms. Perez will figure out what the next steps are after you're here, or you're not. Either way.
Thank you, Judge.
Cool.
No, she will be.
All right. Have a good day.
Thank you.
You're welcome. All right. You're on the record in the matter of the city of Wyandotte versus Lena O'Donnell, 25622AB 24842.
Attorney Corey Westmoreland, appearing on behalf of Miss O'Donnell.
All right. Good morning and so, or good afternoon. And so today's date scheduled for the arraignment pretrial of these matters. Actually,
Your Honor, yes, there was a mistake. One should be a sentencing.
it sure should be. I remember your client.
Yes.
And then she failed to appear for sentencing. Okay.
And at this time, Your Honor, I would just ask that we adjourn sentencing and adjourn today's pretrial for discovery.
Okay, but before we go back, do you want to drink about your name?
Okay. I thought she was already arraigned.
I don't believe so. No, not on the 25 matter.
Okay. We are prepared to have a formal reading of my stands yet.
That's your plea. Not guilty for purpose of the arraignment, and counsel you're asking for an adjournment.
That's correct, Your
The
Honor.
pretrial for discovery purposes.
Correct.
July 16th. Oh, actually, they probably should not do that date because actually the sentencing. Well, that's the only Wednesday Mr. Westmoreland's here in July, so it has to be that date.
That's the only Wednesday?
That's only Wednesday in July.
Wow.
You're on a lot of Tuesdays, a couple Fridays. Only Wednesday in July. Okay, so it's July 16th at 9:45. The court assigned the discovery order. Yes. Yes, to.
Yes, Your Honor. Miss O'Donnell did appear here today on her own recognizance. She actually got in touch with me, and originally, I believe the date was set in July. I had it moved up, so I was here. She assured me she would be appearing at all future court dates. She is gainfully employed at Buffalo Wild Wings, and she knows that while on bond, not accrue any more charges and stay out of trouble, and no alcohol, no drugs.
Does she know that? Because she's technically on bond on her other matter that she failed to appear for.
She does now, Judge, and she wants to take care of these and get everything behind her.
Okay, man, you have a lot that's been going on. I mean, yeah, I mean, you've been. You continue to accrue the same charges. You continue to accrue the same charges. You failed to appear. You've been blowing us off since October of 24. And then now you're here because you received new charges of the same type of conduct. It doesn't appear as though alcohol does any favors for you now.
We did discuss that already, Your Honor.
The court's going to continue on your 256228. The court's going to continue your cash fund. Are you working? You work at Buffalo Wild Wings. Do you have any other than the matters here? Are you out on bond any other matters?
No.
Do you have any other matters pending?
No.
The court's going to order you to have an alcohol teller through the Wayne County Jail. There is what's it called? It's called a walk-in. You can communicate with our probation department because you can go on a walk-in basis there.
Judge, I would just ask, she has to head straight to work from here. I would just ask for at least 24, if not 48 hours to have that.
Yeah, she has to have it tomorrow. Okay, fine. Let me be very, 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 very clear. They will test you tomorrow. And if there's any alcohol in your system, you will take it into custody. So don't think that between now and tomorrow is a free for all because you're not allowed to possess or consume any alcohol or drugs unless prescribed.
Okay, Your Honor, if it is an ETG, she will test positive for alcohol. She did consume alcohol last night. She's not under the influence now, but it will be in her system.
How much did you drink last night, Kim?
Like couple like mixed drinks with Tito's.
Stop drinking alcohol.
Yes.
All of your contact with the law involve alcohol. And yet you continue to drink it. Have a seat. You're going to copy your bond conditions. The court will adjourn the sentencing to July 16th. That actually might have a different date, but for right now, it's July 16th at 9:45. Depending on what happens with the other matter, it may give a turn again. I don't know. But
Thank you, Judge.
nothing to drink at all, or anything else that's not prescribed. Anything else you detected in your system right now?
I do take edibles sometimes to help me sleep, so there might be like marijuana.
Okay, unless you have something from your doctor, if you don't need a prescription or otherwise, then you can't use it. Okay? Stop over probation now.
She's happy of her bond.
Okay, happy bond, yeah, and then go, yeah, start, everything will go over to probation. Fine. Thank you. All right, we're on the record in the matter of the city of White Dockers, Rachel Pinner.
Attorney Corey Westmoreland is appearing on behalf of Ms. Pengar. Ms. Pengar, would you please state your name for the record?
Rachel Wright.
Okay. All right, good morning. You know, just for the record, when you're in court, your shoulders should be covered. And today's scheduled for sentencing in this matter where your client, your attorney had worked out a wonderful deal for you because in my review of all of this, I can't believe that you were offered anything less than PBS charged. Again, I didn't see any videos, but based upon what I have before the courts, your attorney worked out a very good deal for you, whereby this matter was amended to disorderly conduct. Is Eugenia Dyer present in the court? All right, and counsel, did you have an opportunity to review the report recommendation with your client?
I did, Your Honor, and at this time it is factually accurate. There's no additions, deletions, or corrections that needed to be made. I would also just like to point out that we would be requesting consideration for 771. It is the business vendor is eligible. She has no prior criminal history whatsoever. That was just a bad day for her. And totally out of characteristic, totally out of line. She's never going to put herself in a position.
Man, if someone stopped on the person, that there's whatever may have happened in the bathroom, in the hallway, whatever, it's alleged that you ended up going up to the person, putting her face into the door, whatever it was, the glass door. And then when she was on the floor, on the ground, you and the other woman that was with you were stomping on her.
I did not stomp on her, and I wasn't in the bathroom when the original altercation happened.
Yeah, you ended up in the altercation.
Yes.
And you coach kids.
Yes, yeah. I was attempting to defend my friend, and it just got out of control.
Well, according to the report that referenced the video, which I haven't seen the video. Have you seen the video, Counsel?
I have, Your Honor.
I think I need to see the video.
When there was cooking taking place, I was on the ground. I did not hit the victim.
Okay.
It did seem like a mutual combatant situation. Why the prosecutor offered what he did, you know, he has his own reasons for that.
All right. Well, I think I need to see the video.
You know, as to what happened in the bathroom, what started this altercation. Yeah, I was there.
Right. Okay. All right, let me see if if the video is with probation or where the video is to see if that's something I can view right now or if we have to come back. Okay. So we just have to see for 7 months, okay? I run the record in the matter of the city of Rhinelander versus Aubrey Hamer. 25799.
Attorney Corey Westmoreland appearing on behalf of Ms. Hamer. Ms. Hamer, would you please state your full name for the record?
Aubrey Nicole Hamer.
All right, thank you. So today's scheduled for the pre-trial in this matter and counsel.
Yes, Your Honor. At this time, we would be asking for an adjournment for discovery purposes as this incident just occurred. I believe about a week ago. It was rather quick.
Well, yes, because it was today or last week. And we tried to pick the lesser two dockets, although for sure you're having that as well. So, all right, ma'am, if you were tested today, what's in your system?
I might have marijuana in my system, and before I went to jail, I also drank, but this was all before.
Okay. I'll take that. The 16th you said you're back?
That's correct.
You haven't used anything since you got released from jail, have you, ma'am?
No, no.
Okay. The court will still your side, and then what time? 16 now.
10:50.
Yeah, 10:15 a.m. Again, conditions are continued. And we'll see you back on the 15th.
Thank you, Judge.
Thank you. Have a good day. Yep. All right. Okay. So let's who is first? Miguel? Is that Mr. Miguel?
Yes, ma'am.
Okay, very good. Okay. All right. So let's go on the record in the matter of the second lineup versus Michael Miguel, 211-497.
Good afternoon, Ryan John Goldclaw, P 30758 on behalf of Mr. Miguel.
Okay. And Mr. Miguel, your name for the please.
David Michael Magel.
Michael, okay. And would you need the Would you need the prosecutor?
Yes, I did.
No, I forgot what we're on the phone.
Yes, I agree.
No. No. Okay, well, I'll be trying to track that down. Okay, how about your paperwork over there?
Let's get it. Okay, put it. And a different line. Sure, kid.
Okay, well, Councilwoman. Yes, we do need that, please. Okay, so what if that's happening?
It's plea as charged, with recommendation of tester.
Okay, that's the teaching that from the prosecutor. No, it's not, no. You will never find me that here.
Yeah. Okay.
I'm sorry, sir, how do you pronounce your last name? Nagel?
Yes, it's like bagel with an M. Magel.
Okay, sir, I appreciate it. Be careful. Okay. Okay, and so I have
Yes, thank you.
okay. All right, so I'm sorry, ask to be, sir, please raise your right hand. Tell me swear or affirm that you advise you have decided to treat all chickens with pleasure.
Yes, Your Honor.
Okay, and you heard the plea that was placed in the record twice.
Correct.
As to the charge of retail fraud, how do you plead?
I plead guilty because I am guilty.
And you thought you advised the right to your attorney, correct? Yes, you found it in his paperwork.
Pardon? I'm sure it's correct.
You know, you may lower your hands, sir. And you appreciate that financial plea will be waiving some of those rights.
Yes, ma'am. Yes, Your Honor.
All right. And you also receive a possible penalty as a result of your plea, whether in this court or any other court or administrative agency.
Yes, Your Honor.
And knowing all that, I'm supposed to continue with your plea.
I am going to continue with my plea, Your Honor.
All right. And you understand that the recommendation is only a recommendation, and this court is not going to follow that recommendation.
Yeah, the final say is yours, Your Honor. Yes.
And has anybody promised you anything prior to your course to anyway you enter to a plea?
No one has.
Okay.
Your Honor.
And any immigration issues?
There.
All right, counsel, if you can please write your plan.
Thank you. Mr. Miguel, is that correct?
Yeah, Magel is close enough, sir.
That's correct. On August 13th of 2021, were you in the city of Wyandotte?
Yes, I was. Yes, I was, sir.
And when you were in the city of Wyandotte, did you go into the CVS located in Wyandotte and remove a number of bottles of alcohol without paying for that?
I sure did, sir.
And you had no intentions of returning them, did you?
No, sir, I did not.
And eventually you came into contact with the Wyandotte Police Department. And they recovered those bottles and you were arrested. Is that correct?
That's very correct.
And as far as you know, those bottles of alcohol were returned. Is that correct?
Yeah, the captain returned them to the store while I was sitting there. I took them out of the store without paying for them.
Thank you.
Yeah, I stole them, sir.
Defense satisfied, John.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the charge and counsel as to sentencing.
Your Honor, Mr. Megan, this was from 2021.
Right, it's pending because he failed to appear in court.
I understand, John. I discussed that with him. He was going through a lot of problems. That's how the extensive prior criminal record for a period.
There's no excuse, Your Honor. I guess court.
Sir, I can't tell you something right now because your attorney is speaking. But have an opportunity.
That's not the excuse, Your Honor. I'm just bringing it to the court's attention. He did address the other issues between then and now. As we discussed where he had been, he was for a period of time, he was homeless. This all led to his history. It's my understanding for the last couple of years, he's been alcohol free. He's been doing the best he can. He was involved in a very serious accident and about 6 to 8 weeks ago, and he's still suffering from that. He's employed, however, because of his injuries, he's unable to go back to return. We'd asked the defense search on this particular matter, and of course, finds true to that. Believe that under these circumstances, that would be the most appropriate way.
Wow. I am confused that the last day that the officers found a crack pipe bottle. Like, that's how we get back in custody. But that,
Oh, you mean
this time, we use the custody.
But he's not charged with that. Yeah, I know no additional charge. No, I'm not.
I understand that.
And that may have been, like who was going through. We mean found and they arrested him with that. I was dealing with this.
So, Mr. Nagel,
Yes, Your Honor.
is it Nagel?
It's Magel. It's it's like bagel with M. I'm sorry, it's the easy way to pronounce it.
Why did you keep blowing us up? You knew about this matter because you tried to do a plea like that.
Yeah, I didn't know about this.
We didn't accept because we needed a proof of incarceration. We never received that.
I know. I tried writing it from jail. And when I got out of jail, yes, Your Honor, I did not address you. And that is my fault. I didn't put you forefront like I should have. And which I could have put the time aside for that. And I was wrong for that. And it just the weights keep coming over my shoulders and it's my fault. I have no excuse. I cannot think of an excuse to tell you.
Listen, pick some individuals that are less likely to get into trouble, right? From their behavior, and keep it together. You gotta keep it together, sir.
Your Honor, I like I said, I have nothing I can even come up to an excuse for other than I disregarded you. And I'm being honest, I didn't think twice about it, and I apologize.
Okay, hold on. And then you keep getting in trouble for the same offense.
Yeah. Yes, I did. And
It's correct. It's obvious, Your Honor, from his record, that he was using retail fraud to support himself. That's obvious.
And it appears, as you indicated, he was incarcerated and trying to be he should have followed up once he got out. Go down. Can I say something? I have resources today, Your Honor, that I never had before, and I'm going to actually take advantage of them. I'm not trying to take advantage of the state itself, but I do have people that are offered to help me with food, shelter, just to stay sober. I almost died twice this year. It has nothing to do with this case, but my mind is about just living my last days with happiness and peace and trying to pick up the old debris I left behind. Part of my debris.
All right, well, here's the court's version, because, sir, since you've absconded on this matter, you continue to get in trouble and charged and plead to retail frauds.
Yes, ma'am.
So the court's version is the court's version over 60 days jail, for 7 days, wait to find the costs, and you're all set.
Thank you, Your Honor. Your Honor, right? I'm sorry, I'm kind of hard of hearing. Can you please?
60 days jail, credit for 7 days, waiting to find the costs.
Thank you, Your Honor. Thank you, Your Honor.
You're welcome. Good luck to you, sir. So you're also letting me know that your matter is final.
All right, thank you. Bye.